Well, hey everybody, welcome to today's webinar. Thank you for joining us today. I'm Mike Swanson. I'm the CEO and President of Advocate Capital, and we are the sponsors of today's webinar. I'm also the author of the book, How David Beats Goliath, the only finance training book ever for plaintiff lawyers. And if you'd like a copy, just message me. I'm happy to send a copy to you. As I mentioned, today's webinar is brought to you by Advocate Capital Incorporated. We are the purveyors of the AvoTrack Case Expense Funding Service. More information at Advocate Capital. Quick disclaimer, this webinar is for informational purposes only. Don't take any action or fail to take any action based on what you hear today. If we get into business, tax, legal issues, be sure to consult your independent counsel and advisors. So, without further ado, I'd like to introduce you to our special guest today. Mr. Phillip Miller is joining us, also from Nashville, about 15 miles north of me right now. He is with the Miller Law Offices. He is nationally recognized as a trial consultant and attorney, board certified as a civil trial advocate, and he has written 2 books. I only wrote 1. So, Phillip, are you there?
I am.
Hopefully Phillip's there.
Oh,
I can see you. There you are. Hi.
good.
Hey, thanks for joining us today.
I do.
Sure do appreciate it. So Phillip and I are broadcasting live from Nashville, Tennessee. Today is March 25th, 2020. So if you're watching this as as a recording later, the reason that we don't have our studio together, this is my bonus room at my house. We are working from home because of the COVID outbreak. So we want to keep everybody safe. So sorry we're not in the studio. That's the way it goes sometimes. Great. So Phillip, you're a trial expert. You've written 2 books. I think the most recent book just came out, didn't it?
Focus Group Hitting the Bullseye came out, I guess, 2 years ago now.
Oh, was it 2 years ago? Wow, time flies. I think I saw you at AAJ doing a signing, something like that. So, so first of all, we're going to talk about a couple of topics that I know are on your list today, and one is how first instincts about what are important are often wrong. Can you tell us about that?
Yeah, I mean, it's really a couple of things. One of the things is that sometimes immediately and then over time, we always fall in love with our clients. And when that happens, we're not really seeing them and seeing the case with the same lens that someone who doesn't know anything about the case, doesn't know anything about them, has no investment at all, might see that same set of facts and that same client. So one is we do kind of fall in love with our clients, and that shapes the way we view them and view the case. And the second thing, our instincts about what's important is wrong, because what's important, we think, is what's important to us, or what we think should be important to anyone else. And there's a big chasm between what we think should be important and what actually may be important to the people who are deciding the case.
Interesting. Okay. I think next you want to talk about Prima Facie, and I'm not a lawyer. I'm not even sure what that means.
Well, I mean, you know, I think any good lawyer is going to look at the required legal elements of the case, the Prima Facie case. What is everything we have to do? So in a typical negligence case, we have to prove duty, breach of duty, causation, and then damages. And so we tend to focus on that's what we have to prove. That's what our proof is. And the problem is, that's what our proof is. But when people make decisions, the kind of people that are in jury boxes all over the country, you know, they're not thinking about duty, breach of duty, causation, and damages when they make their decisions. You know, they're thinking about what's right or wrong, what's fair or unfair, and they may be thinking about things that have nothing to do with legal duty, breach of duty, causation, and damages. And so we prove all that stuff, and maybe there's still something out there that they wanted to hear about, that they needed to hear, that we haven't given them. So the Prima Facie fake case is never enough for that reason. They want to hear other things and about other things that we might think are irrelevant.
Huh. And how could a lawyer get to the bottom of some of those issues before a trial? Is there ways to try to work on that?
Yeah, there's several ways. I mean, sort of the number one way is that, and perhaps oversold a little bit, is to use focus groups, because focus groups of people that are independent of you, independent of the case, don't know you, don't know the client, and are going to give their unvarnished opinion about case issues, and their unvarnished opinion may be very different than what yours is. So that's one way to kind of get at what other kinds of information are we going to need to talk about. For example, you may think a piece of evidence is really strong, It's part of your prima facie case. You say, this is absolutely adequate. We've got it done. And then, when you actually test it with people, they just don't get it. Or maybe they think the proof isn't strong enough. So what we think is enough is really almost never enough.
Yeah, I've seen some really interesting presentations on focus groups and how you learn things you weren't even thinking about. Like someone asks a question about you didn't think it was even a part of the trial or your presentation. And so I've seen a lot of lawyers have great success focus grouping, even several times prior to trial.
Yeah, I mean, the earlier and the more often, the better is sort of the general rule, because you can get way into the weeds on a case, into things that the jurors aren't going to understand, maybe not, may not even care about. You can spend tens of thousands of dollars of experts that the jurors are going to kind of discard.
Wow.
Before you do that, you probably need to find out what are the kinds of things that they want to know about, and what are the things that they're having problems with that you think should be self-evident.
Now, is conducting focus groups something you help lawyers with?
Yeah, I do it all the time. Although Paul Scopter and I wrote that book on focus groups, and it's really a how-to book, so people can kind of do it themselves. But the fact of the matter, just like anything else, there's some people that really can't do it. It's just they can't set themselves aside from their feelings for the client, their feelings for the case, their own sort of wanting to advocate and fight for their case, and you can't do that in a focus group. And so it's not for everybody, but it's a good source of information. I'd say there's a quasi substitute for people that just can't stop advocating and can't sit there and listen to people just pummel their client and pummel their case. Then one of the things, sit down and really work through and build a model of what the other side is going to say in detail, in writing, and then figure out, do you have answers to those questions? Because if you don't have answers to those questions, your jurors aren't going to have them. And so everything I tell people, if you look at the case through the lens of a defense juror and everything they might conclude or think about, you're on your way to building sort of a model of what the opposition could actually put on as proof in their case, or that the defense juror could talk about in deliberation.
Right, fantastic. Well, I know you have 5 factors that drive juror decision making. What are those?
Well, so I've done, well, I guess I only did 4. I did 4 focus groups last week, but I've done hundreds of focus groups, and you hear a lot of the same things being repeated every time. And so when we think about the case that we're putting together, so we're in Music City, so I'll use a Music City metaphor or analogy at least. My brother-in-law is a famous country music songwriter, and he was speaking to a bunch of trial lawyers about themes and how do you come up with a hook or something that's going to resonate with a lot of people. And one of the questions they asked him is, how do you figure what your playlist is when you go and do a live performance? And he said, well, the number one thing is you have to know your audience. Because you can play a song that's a hit, and lots of people love it, and you're in front of the wrong audience, it's going to fall flat. And so we have to know our audience too. It's exactly the same kind of thing. And here's the thing our audience wants to know, or they want to talk about. So number one, these are people that are brought in. They may not be happy to be there. They may be fine with being there. But the number one thing is they want to feel like they're doing something that makes a difference. They don't want their time away from their home, their job, to be trivial and unimportant. So the number one thing we have to do in our case is, what about this case is going to allow them to feel that they're doing something important? If it's just about money, well, you can still get a verdict in that case, but they're going to really fight hard for you if it's just about money. Number two is, we are in we're regardless of whether it's a red or blue state or conservative or progressive, it doesn't make any difference. We as a people are really very conservative in terms of the way we look at things. And one of the things that we hear from jurors all the time is they want to punish or affect change. If there's bad conduct, then they want to make a difference, which means they want to punish the person or they want to affect change in some way. And the way they punish people is by awarding damages in a verdict. So that's number two. They want to know if they want people to feel they're doing something important. And number two, they want to be able to affect change and punish if that's what you're calling. Number three is they're always suspicious. if we tell them that this is uncontroverted, uncontested proof, they're not necessarily going to believe us. And so every piece of evidence we have to have it backed up by something objective. It's not just what we say.
Yeah.
So when we go into what our proof is, well, could they be suspicious of this element of proof? And the answer is they're always going to be suspicious. How do we deal with that suspicion? And the time to do that is before you walk into the courtroom. Number 4 is they always want to know the prior history of the conduct of the two parties. Because remember, they want to be able to send a message and punish. So if this is something that's happened again, why didn't they learn their lesson? Prior history of the parties is always important. But for plaintiffs, that also includes the prior medical history. Because if there's anything in the prior medical history, the jurors will use that and say, well, aren't they just piling on here?
Right.
So we have to think about that and be prepared for that, because they're going to be always looking at that prior history. Now, when there is one of the terms of art that's used for the same concept is what's called OSI, other similar incidents. And when we can establish that there have been other similar incidents involving the same defendant, the jury's going to say, great, we need to send them a message. And when they have that kind of attitude, you're making the case bigger than one event. They have an opportunity to send a message. They feel like they're doing something important, and they're going to deliberate harder for us in a deliberation.
Yeah, that reminds me of Hot Coffee, the movie. Every employee of Advocate gets a copy or views that movie. I remember how the McDonald's executive was testifying there had been like over 700 prior incidents of the hot coffee burning people. So, obviously McDonald's knew there was a problem. So that was very powerful to see that came out.
Yeah, and without it, it's just an accident. When there are similar events, it's not an accident anymore. It's a failure to take some sort of corrective action.
Yeah, and your number one point, if I may add as well, it's kind of like Simon Sinek's book, Start With Why. People know what to do and how to do it, but why am I here? Why am I doing it? It's so easy, I think, for plaintiff lawyers when they're managing their business with their employees to have such a strong why. Why are we doing this all day? We're doing it to help people all day. So it makes total sense to me that you need to get the jury thinking that way as well. So.
Yeah. And then, of course, I think the last thing is, now, by the way, I'm giving you 5 things. And there's lots of things jurors want to know about and we'll talk about. Consistently across group, across any kind of case, these 5 things seem to come up over and over and again, which means if we hold them into our case preparation, we're going to be better prepared. We're going to know what the set list needs to be for this particular audience. The last thing is because they know they're going to have to go in and deliberate and decide the case, they want to know if there's any rules. So how do we, because there's conflicting facts always, but are there rules? And if there are any rules, there's some people who just absolutely enforce those rules regardless. I mean, if there's a rule, it's violated, we're enforcing the rule. Other people are maybe a little more measured, maybe some back and forth, but they always want to know are there any rules. And the thing we have to remember is there's rules for both sides. There's not just rules for one side of the case. And so we have to think about any rules, including maybe rules that our own clients violate.
So what kind of rules are you talking about?
If you are on a bus going down the interstate at 70 miles an hour, you shouldn't get up and walk down the aisle, right? For example, if you're approaching a yellow light, you should slow down and use caution. Or if it's raining and you're going 50 miles an hour, you should slow down to avoid hydroplane.
Right. Okay. I was thinking maybe it was like rules of evidence or something, because I'm not a lawyer.
No. Well, the answer is the rules have to be designed for people who aren't lawyers. They have to be commonsensical. For example, anybody would know if you're in a bus and it's going 70 miles down the interstate, you probably shouldn't be walking up and down the aisle because it's going to be unsteady. And if you're approaching a yellow light, you should approach with caution. And if it's raining, you should probably slow down to avoid hydroplane. So those are the kind of examples, the kind of rules that are most effective. Now, we have experts in our cases, and sometimes people spend thousands and thousands of dollars on experts, and sometimes experts can be a source of rules. But if it's the expert's rule and it doesn't resonate with those jurors, it's not going to have the same impact. So if you have a really good expert who's teaching the jury and the jury's nodding their head and they understand this rule and they get it and they agree with it, thumbs up, good. But if it runs counter to common sense.
Sure. Yeah, makes sense. Cool. Well, thanks. Well, folks, this is just one little snippet of Phillip's knowledge. You get a little taste for his level of authority and why he's such a very effective and popular trial consultant. So we'd like to open up for questions. If you have some, we'll give you a few moments to type them in. Once again, I want to apologize for some technical challenges we're having today because I'm broadcasting from my bonus room at home due to the COVID outbreak. And we have a lot of attendees on right now. I'm guessing a lot of you are kind of sheltering at home as well as I am. And so we're going to give you a chance to add a few questions. And I think, Phillip, you may be able to see them on my end, and I have my team quickly emailing to me if you have questions. Folks, feel free to ask. We don't know who you are. We're not going to mention your name. This is anonymous. We'll give you a couple chances. So we had a tornado here in Nashville early on October 3rd. And Phillip, where were you when the tornado hit?
I was home, and I live on the west side of town, so
Okay.
I heard we have tornado sirens in Tennessee, and I heard a tornado siren was pretty close to my house going off at 12:30 at night, and I got up, but there was nothing going on where I was because the real cells went around sort of my neighborhood, but they went through the area where my office is, which is where I'm sitting right now. I am sheltering alone in my office. Everybody else is home.
Okay.
So we lost some solar panels off our roof, blew down a fence, took some shingles off the roof. The real damage was about 3 blocks down the street because they're just leveled buildings.
Just 3 blocks away?
Yeah.
That's incredible.
There's a famous picture now of a demolished building that has a sign painted on the side that says, "I believe in Nashville."
Yeah, I've seen that.
That's the Basement East, which is a music venue, and it's just 2.5 blocks from the office, but just level. And we have a lot of blue tarps on roofs here now.
Great. Well, I'm glad you're safe and sound. It was a scary time for us, and now the COVID thing. So these are uncertain times. Hopefully, we can get everybody hunkered down and safe, and we get past this. So I'm not seeing any questions on my end. Phillip, are you?
Yes. Can you list those 5 factors again? Yeah, I'll be glad to. So number 1, jurors want to feel that they're doing something important. And so this is sort of what you've probably heard about jury empowerment speeches, where we make an effort to emphasize how important their role is and how important it is their participation in this process. If they feel they're doing something important, they're going to go into a deliberation and they're going to fight a little harder, they're going to be more engaged, and that's what we want. So that's number 1. Number 2, they basically want to affect change, and generally that means punishment. And they understand that if you punish, the way to punish people is you punish them with money. So number 1, they want to feel like they're doing something important. Number 2, they want to punish or affect change, which is why we're always looking for bad facts and bad conduct, because then there's a way for people to do that. And number 3, they are suspicious. So of all your proof, even if it's uncontradicted, they're still going to be suspicious of it. And how do you reinforce and amplify that particular proof? So in a brain injury case, for example, you can bring in all kinds of experts on brain injury, but sometimes the most effective witnesses are the before and after witnesses. And so that's, we have to deal with the suspicion, including the suspicion of expert testimony. Number 4, they always want to know the prior history of the defendant's conduct. Had this ever happened before? And it expands to, what about the plaintiff? Had they ever had the same symptoms or problems in their past? This all sort of boils down to what's also called OSI or other similar incidents, which is very powerful when you have it in the case. And number 5, they always want to know if there's any rules that they should be applying in the way they look at all this conflicting evidence and arguments.
Awesome. And I apologize to my viewers. I have to ask my guests to read the questions off because the technology here is not cooperating, so I'm not able to see them. But do you see any further questions?
Yeah, I actually do you have any suggestions for remote focus groups at this time? Yeah, I did 2 last week.
Wow.
And so the way that works is that you have to prepare a narrative, right? A neutral narrative, which incorporates, the facts, the kind of facts that either side is going to want to have if someone's going to be thinking about or talking about their case. So you have to prepare a narrative, and then you have to prepare a list of questions over what you think are the key issues for both sides. And typically those questions are scaled, what's called a Likert scale or a Likert scale, 7 points: strongly agree, strongly disagree. And then you have some open-ended questions as well. And then you basically, the way the online groups is they will log online, they will read the narrative. It'll include video, it'll include pictures, it'll include your narrative, and then it includes all of these questions with all the follow-ups and fill in the blanks. And that's what you get as response. What you don't get is you don't get that back and forth discussion between two people who are agreeing or disagreeing at a point, but you get lots of information on what you've identified as the key issues in your case for people to comment on. So I think they work fine. They are they're not a replacement for a live focus group, but they're pretty good if you're trying to find out and get good information about your case.
Yeah, do you set up with webcams or something?
Yeah, actually it's done. You know, when we think about online focus groups, they're not typically done with you and like a webinar where there's all these faces and heads talking. It could be done that way, but generally they're done online where someone logs on to it. They hit a link, they get the entire narrative of the case, the pictures, the videos, the questions, and then they get paid for the participation. And and so they never see the other or have contact with the other people who comment.
Yeah.
Of course, one of the things you can do, just like any other focus group, is you can pre-select who do you want to have responding to your questions. I just don't want 12 random people. I mean, I want people who I think are going to have we're going to create sort of a robust conversation about the issues in the case. And so if it's a medical case, for example, you'd always recruit people who have a medical background. And if it's a case, you'd always recruit people that have a CDL. You want to hear from people who might be defense oriented, because that's the way you're going to have to ultimately counter the defendant's case, and then they give you some good cues as to what the defendant
is. It almost like a voir dire kind of? You want to select the right jury?
It's not, yes, in fact, because if you do enough of them, you start seeing, you can potentially see a pattern. A certain kind of people just don't seem to be very good for us. So I'll give you an example, and I think we should be careful to generalize this. But if you have a case where you want the jury to punish conduct, okay, there are some people that don't believe in punishment. And so, for example, I did a group, and it was probably 2 months ago, and I ran into this twice within a period of just a couple of weeks. One of the persons happened to be a nurse. I think the other one was a social worker. They just didn't believe in punishment. So there's no way they were going to deliberate. This was a case where primarily the real issue was punitive damages, whether the conduct was reckless and willful and wanton and all that legal stuff. But if you have someone who doesn't believe in punishing, well, you can't have them in your box. I mean, you know, if it's about punitive, they're going to hang up the jury, or they're going to hold down the amount of the verdict.
It's a good point. I hadn't thought about how voir dire is important, but I never thought of it kind of applying also to your focus group. It's a good point.
Yeah, well, you can learn about, I mean, for example, if you don't want to learn that out of the actual trial, you want to learn it out of some focus groups. So you start getting a feel for the kind of people that may or may not be bad for you. And sometimes, you know, you just don't, I'll give you, here's another, this is one of my favorite all times, and I better get to another question. I did some cases that, I've done a bunch of cases involving birth injuries, which always have, you know, just sort of horrible consequences. Sometimes the child doesn't live, and so you still have a case, but the child didn't live, and the case then is for the wrongful death of this infant or this baby during delivery. And if you have somebody on the jury who has experience, for example, someone who breeds dogs, they breed 6 or 8 litters a year, and every year with every litter or maybe every other litter, they just have a puppy that doesn't thrive, and they have to pick up that dead puppy and get rid of it. Now, they've done everything they can for the mother they can, nutrition, food, everything.
Yeah.
What is the conclusion as to why the puppy died? It just happens. It's nobody's fault.
Right.
So when that happens with a baby in a medical malpractice case, and you got somebody who's a dog breeder, it may not be easy for them to come back and return a verdict saying that anybody's at fault, because their own experiences, it's just nature, it just happens.
It's happening.
The baby just doesn't thrive. And so you learn as a result of doing it. Now, I've done a gazillion focus groups, so I've learned a bunch of weird stuff like that nobody else would ever want to know. But the more focus groups you do, the more little tidbits you pick up that help you when you're actually going into the trial. Because
Right.
you know, that doesn't mean you would exclude every nurse or every dog breeder, but I think I'd have a conversation with them, right?
Yeah.
I got a question here.
Yeah.
How do you read the tea leaves with jurors to know when you're getting through to them during the course of a trial? I don't know. You can't depend on people smiling at you, you know, and you can't depend on them nodding their head. You know, the answer is they might be nodding their head and they're good for you, and they might be nodding their head and they're not. So I don't think that that is something that no, there are people who are trained observers that do this for a living that are much better at it, not you or I are. But by and large, I don't think we should try to read the tea leaves during deliberations, during a trial to see what jurors are thinking, because, well, you know, it's you know, even when it seems obvious, we don't necessarily know what it really means.
Right. So someone emailed in a question for you. Please tell us more about how you suggest getting the jury to follow plaintiff's rules versus the defendant's rules.
Oh, well, the answer is it's helpful if you know what your rules are and the defendant's rules are before you step into the courtroom. Right? And then one of the things you can do is you can kind of test it. I mean, okay, what do people say? So, I mean, the easiest focus group in the world is when you're just asking them to test rules. Now, do they equally, if you give them some context, you know, which rules do they more strongly agree with? You know, how is the rule framed? And so maybe if you think, you know, they're more likely to attach to the defendant's rule, then the question is, how do we reframe our rule so it's more successful? But I don't think there's any way to do that other than in advance, build a model of the opposition case, think about what the rules are going to be compared to yours, and then say, I mean, I have my opinion about them, you have your opinion about them, but what do ordinary people could be on a jury think about when they're given those rules? Do they conflict? Can you reframe yours? I'm not sure I'm answering the question. It's a tough question, and the only way to do it is work.
Well, Philip, this has been really interesting. I've learned a lot today. I'm sure our viewers have as well. If someone has a question and that they'd like to ask, wait, hang on, here's a follow-up. As a follow-up to a remote focus group question, how do you find them online? How do you find the online focus group jurors? Good question.
Well, there are people that do nothing but run online groups. So find somebody who does online groups, tell them what you're interested, get an idea what the budget would be, and use them. You don't want to try to do this yourself. I mean, I suppose you could, but most of us are better served spending time on the file, not on the mechanics of getting people to participate in an online exercise. So okay. I would go find somebody who does online groups, talk to them, see what the budget is, and then spend your time working on the narrative that they're going to be provided, which is balanced, right? And then the questions that you're asking to respond to, which are going to really tell you something about the case that you didn't know and help you in terms of developing your strategy.
Great. Well, our viewers don't want this to end, which is wonderful. So you have time for another question?
Sure.
In the small to medium-sized personal injury case, how do you overcome jury prejudice that may have a predisposition against plaintiffs because of the current political climate? Is it even more difficult to try cases for plaintiffs in the current coronavirus climate?
Well, I mean,
the question there, the corona question, I think maybe it's.
The corona question first, because that's the easiest. First of all, nobody wants to be in a room with perfect strangers for hours at a time. Period. End of story.
Yep.
So when is that going to go away? I don't think it's going to go away when someone blows a whistle and says, okay, you don't have to shelter at home anymore. So that could be with us for a while. If someone's called to jury duty, for example, if people are called to jury duty in September, are we going to have the same response in September 2020 that we did in September 2019? I guess we'll see, but I think there's a possibility that people will be reticent to even respond to a jury call.
Yeah.
They don't want to be. They don't. The whole idea of being boxed up with a bunch of people may really bother them. See, but other people just don't care. I mean,
Yeah.
They're congregating in groups, they're doing things that I wouldn't do and you might do. But so the coronavirus has that, I think it's going to have an effect. We just don't know for sure what it is.
And how long it will last.
In terms of the responding to, a small firm, small case, the answer is, the number one things is, if they like your client, if you've got a good client and it's a legitimate case and they like your client, you're going to do fine. The problem is that we probably, because we fall in love with our client or we fall in love with the facts of the case, we forget to look at the case like others would. But if they really like this person, then you're probably going to do okay. But if we like them and everybody else is going to, or maybe if we don't like them. I mean, I have talked to dozens of lawyers. They had these cases and they were complex and they're putting a lot of time and money into them. And at the end of the day, they didn't even like their client. And the reason they didn't like their client is there were things wrong with their clients. It could be a variety of things. But, if they didn't like him, is the jury going to fall in love with him and go, probably not.
Probably not.
So the number one thing is you got to have a client that the jury's going to like, because that's half the fight.
Yeah, I guess it's kind of unfortunate. If you're likable, you're a better plaintiff. Not sure that's fair, but that's the way it goes. Okay, I don't see any more, but everyone's hanging on and are so excited as I am that you're willing to share your knowledge today. And Phillip also shared with us his contact information. So if you have a question that didn't get answered or you didn't really want to ask on the webinar, this is his contact info. Thank you for sharing that, Phillip. And so you'd be willing to talk to one of the folks who are on the webinar if they give you a call about it, something, or follow up, something like that?
Sure. And so my staff is sheltering at home. I'm at the office, but if you just call out the regular number is area code 615-356-2000. 615.
Okay, say that again. Say that again.
615-356-2000. They call that number. I'll get the message. I'll call you back, or you can email me at PMiller@seriousinjury.com.
Okay, fantastic. And we'll try to include that in the follow-up email. So our viewers, and even those who signed up but didn't attend, will get an email link to a video recording of this presentation. If you would like a copy of my book, give me an email or a call. This is my contact info. This webinar was brought to you by AAJ Capital. More information at our website. And if you would like more content like this, you can visit lawpracticechannel.com. We thank you for attending. And Phillip, thank you so much for taking time away from your busy consulting and law practice today. We sure appreciate it.
Thanks, Michael. It was a pleasure.
All right. Thank you, everybody. Have a good day.